السلام عليكم ورحمة الله وبركاته. الحمد لله وكفى والصلاة والسلام على عباده الذين اصطفى. أما بعد، رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. رب زدنا علما، رب زدنا علما، رب زدنا علما نافعا. آمين. We were discussing about the legal philosophy in Islam. And if you remember, we said that our discussion will revolve around answering some important questions about legal philosophy. The previous question which we took was about the nature of law. What is law? And in today's session, we will take another question, which is about legal validity or legal authority. Why should we follow law? Why is law binding? Where does law take its authority from? These are some important questions in legal philosophy generally, and Islam has the most balanced answer to this question also. In the Western legal philosophy, this question is considered the most complex and difficult. As one of the philosophers of Western law says, the problem of how the nature of law relates to the source of obligation to obey is one of the most complex and paradox-ridden areas in contemporary jurisprudence. So in the modern and contemporary Western jurisprudence, this is the most complex question. Why? Because the Western legal thought does not involve religion and morality. For this reason, it has become the most complex and paradox-ridden, as he says, area in contemporary jurisprudence. Where does law take its authority from? Why should we follow the law? And this has also a relationship with the previous mas'ala about the nature of law. So when we say this legal code or this particular law is reasonable, so we are involving reason, or we can consider it beneficial for us. If we don't follow the law in a particular society, it will harm the society, it will harm the human beings. So we are involving utility, we are involving benefit and harm. These are some important considerations in the Western legal thought. However, Islam again differs uniquely from the Western idea of law in this particular matter also. So in Islam, rationalist thought, it on its own is insufficient. We cannot base law purely on rationality, purely on aql. Intellect is involved in understanding and application of the law, but law cannot take its authority purely on rationalist considerations. So in the West, rationality and the custom of the society are primary sources of law. We must follow the law because it's reasonable. We must follow the law because the society has a contract with the authorities who coined the law and imposed the law. Whether this contract is hypothetical or it has happened in history, this is another discussion. The society must follow the law because it's beneficial. If we don't follow the law, we may return to the state of nature. The state of nature is evil in itself, and these are important terms. I'm not going deep into the Western philosophical tradition. This is not our topic. But if you study the Western legal philosophers, these are the main considerations in their theories. We must follow the law because it's beneficial. The original state of nature is chaotic, it is evil, and if we don't have law, human beings will harm each other. And in the terminology of some other philosophers, it will cause inconvenience. It may not be harmful, or it may not lead to war like situation, but it may cause inconvenience, again hardship. So revelation is not a consideration in the Western legal philosophy. However, Islamic legal philosophy or Islamic legal tradition is the fine balance between reason and revelation. So we can say the marriage between reason and revelation is the ultimate source of law. This is a very important point to understand. We can say the marriage or the fine balance between reason and revelation is the ultimate source of law. Or the law takes its authority from the fine balance between reason and revelation in Islam, is the ultimate source of law. So this fine balance has been achieved only in Islam or Islamic legal tradition. And now this takes us to another important term, which is rule of law. This is a very common term used in our times. On some occasions, this is also used to highlight the importance of the Western legal system and the corruption of the political and legal system in the Muslim world. So we lack rule of law, and the West has rule of law. Now, rule of law has also been discussed from different angles. It is not a term to be taken for granted. Does rule of law exist with objectivity, or it is a term to cover the will of the sovereign, the human beings, the legal authorities, those who propound the law, those who coin the law? So does it really exist? Is rule of law the ultimate principle, ultimate authority in the Western legal tradition, or it is a tool used by the politicians and those who are in authority? This is a very important question. And some contemporary Western legal philosophers have clearly explained that rule of law is not an objective principle. Rule of law is basically the will of the sovereign, the will of the ruling authorities, the will of the political state. Because the state in the Western system plays a very important and basic role as a legal authority in creating the law. We will come to that. So rule of law is not a sublime principle to which all political authority, rulers, kings, courts, institutions are subservient, but rather it is a compromise between these ruling authorities and the codes. So rule of law is also a very important matter. Basically, this question arises because the purpose of law in Islam is completely opposite to the purpose of law in the West, as it has become in the Western modernity or post-modernity. So if we summarize it after reflecting on the Western legal philosophy and the theories in legal philosophy, we can say the purpose of Western law is control and discipline. Yeah, I'm giving you the summary of my readings and study. And if you go deep into these points, you can refer to the books about Western legal philosophy and the theories, you will find the description, you will find the details. We're not concerned about that here. So the summary, if we compare the purpose of law in the Western legal tradition in Islam, we can say the purpose of law between Islam and the West, or Islamic legal tradition and the Western legal tradition. So we say the West is control and discipline. Control and discipline. Discipline. Which is implemented by the political state. The state controls and disciplines. Controls by legislating and disciplines by punishing if people go against that legislation. So what human beings do beyond this area of strict obedience, and if they don't obey, they will be disciplined. The modern state does not have any concern beyond this activity, because it's not concerned about the morality. So the state does not have in the least any interest in what individuals do outside of its spheres of influence and concern. So what this human being does in his private capacity, which does not concern the society and the state structure, the modern state does not have any concern with that. So the state does not have in the least any interest in what individuals do outside of its spheres of influence and concern. This is completely opposite to the Islamic legal system, because Islamic legal system is about actions of the mukallaf. It is about actions of a human being, which involves morality at the same time. So in Islam, law is directly involved in morality. Law has great concern and interest in all actions of the individual. Not only those actions which concern the society or the state structure, but all actions. That's why this structure and classification of ahkam, which we have, the 5 types of ahkam and sharia rulings: al-wajib, al-mandub, al-haram, al-makruh, and al-mubah. This is basically dividing human action. All human actions can be classified into these 5 types. So this is a primary distinction between the Western legal system and the Islamic legal philosophy. So if we say Islam, what is the purpose? The purpose is to foster living in peace with oneself and with society. So this is a moral concern. This is very important. Foster living in peace or tranquility with oneself and with society. So this is the main distinction between the Western legal system in answering this question. Now this takes us directly to the question: authority of law. Here we have different Western legal theories. We will mention the crux or the summary of it without going into the details about who propounded it, the names of these philosophers, and the details. That will take us out of the context that we have here. So here the main question of legal authority is law or legal obligation simply a reinforcement of moral obligation? We must follow the law because as human beings we are morally obliged to follow it. This is our moral duty. Or is this obligation derived solely from the legality, not from the content of the law? These are the two different opposite poles. So do we follow the law because we are morally obliged to follow it? Or we follow the law because of the law itself? It may be oppressive, it may not fulfill the principles of justice, it may not be morally justifiable, but we have to follow it. Why do we follow it? The Western legal philosophers have detailed theories in that and answers. One of these theories is the theory of contract, or contractualism, as it is called. We have a contract. Those who follow the law, the followers of the law, the objects of the law, they have a contract with the authorities. They have accepted them as authority. They have accepted them as legislators. Now they cannot question the content of the legislation. And we are talking about human beings. We are not talking about God, because religion is not involved. And then they also discuss about the nature of this contract. Has it happened in history, or it is just hypothetical? Why is it hypothetical? Because in order to uplift ourselves from the state of nature. The state of nature is evil. The original state, as some legal philosophers call it, with some here differences in the explanation. The original state, or the state of nature, is evil. It is the state of war and dispute, disagreement. If we don't involve law or implement law, create law in a society, human beings will suffer. They may destroy each other. And in the terminology of some other philosophers, we may face inconvenience, we may face hardship. So the state of nature is evil based on this understanding. In order to create harmony in the society, we must accept the law and the legal authorities without reflecting on the content. Forget about the content. So the obligation, the authority of the law is solely derived from the legality itself, not from the content of the law. Now this is to abandon morality altogether. As I said, the state doesn't have in the least any interest in what individuals do outside of its spheres of influence and concern. It is only interested in this control and discipline in the domain of the state, in the domain of the society. In individual capacity, the Western legal philosophy does not concern itself with creating a good human being. The law is to refine the morality of the human being, to create a human being who acts in a moral way at individual level also. The modern state and the Western state does not have any such concern. However, as I said, Islam differs in this also. In Islam, morality is directly involved. So that's why we have this classification, as I explained. Following the law is not only because we want to create harmony in the society, only because we don't want criminal activity in the society, only because if we don't follow the law, we will suffer harm. But the primary function, the primary purpose of following the law is because this is morally binding on us. We are mukallaf. So Allah made us mukallaf. Human being is legally responsible for his actions. Responsible where? Responsible in akhirah. This connects us with the concept of akhirah. So metaphysics is involved. Morality is involved. We follow do's and don'ts, awamir and nawahi of Allah subhanahu wa ta'ala, not only because it is beneficial for us. That's why we have this discussion in the chapters of qiyas, analogy, about illah. There is an area of legal injunctions, do's and don'ts, which are غير معقولة المعنى. They are غير معقولة المعنى. They have a wisdom, they have an illah, a cause, due to which This rule was legislated, but we may not understand it. And this is usually specific with ibadat. Why do we have 5 times prayer, not 6 times or 7 times? The rak'at of the prayer, for example, these are best examples we can give. The rak'at of the prayer, why is Fajr 2, Dhuhr 4, Maghrib only 3? The adhkar, for example, after the prayer, Subhanallah 33 times, why not 34 times, 35 times? Why not 50 times? Praising Allah more was better. So this is غير معقولة المعنى. That's why qiyas does not apply here. We cannot apply qiyas in ibadat. We cannot apply analogy in ibadat, in the area of ibadat. However, there are some scholars who disagree with this principle also. They apply qiyas in some branches of ibadat, like the Shafi'i jurists. But this is a general principle. We apply ibadat in mu'amalat. We apply qiyas in mu'amalat, in the area of human dealings, in buying and selling, in the nikah and the social responsibilities, in inheritance laws, because they have clear reasons which can be understood directly by the aql. So if reason or utility, benefit, harm, the original state, the state of nature, if this was the these were the sources, or these were the justifications for legal authority in Islam, then we would never have an area in which we don't understand its reason. We follow it only because it is command of Allah. We follow it only because it comes from Allah subhanahu wa ta'ala. Revelation is the most important reason and the ultimate authority. And subhanallah, this connects the discussion with epistemology also. We don't only believe in revelation to be the greatest source of knowledge or the ultimate source of law. There are some allied and sub clauses connected with the revelation, like the dreams. Dream is also a source of knowledge, with, of course, with conditions. As the Prophet ﷺ said in many ahadith, dream is part of nubuwah, part of prophethood, true dreams of true believers. We have ilham, intuition. It has been accepted even as a source of law by the most strict legal philosophers, like Shaykh al-Islam Ibn Taymiyyah. If you study the volume of Tasawwuf or As-Suluk in Majmu' Fatawa Ibn Taymiyyah, you will be astonished. His discussion about the ilham, intuition. So he says intuition is a better source of law, a better method of law than many weak qiyasat, weak analogies, weak ahadith, and masalih also, maslaha, utility, benefit. And it can be applied even in criminal law. Imagine, this is a very difficult position. A mujtahid, a scholar, a jurist can apply ilham, intuition, in the court procedure. He can give not only on ilham. Ilham is a supportive evidence, but he can use ilham as a supportive evidence in his legal judgments. So revelation with these branches, which are based on revelation, and as we know, revelation is ended with the last and final messenger Muhammad sallallahu alaihi wasallam. But these allied branches, which are connected with revelation, which take its authority from revelation, they will continue till the end times. The true dreams will continue till the end times. The ilham will continue till the end times. The kashf will continue till the end times. These are sources of law, methods of law, as well as the sources of knowledge. However, with conditions. This is not a cup of tea for every Tom and Harry. So in Islam, we can say legal authority is epistemic rather than political, social, or even religious. Legal authority is epistemic in the fact that legal authority in Islam was always personal and private. This is another important point here, which we must understand. Legal authority in Islam is personal and private. What does it mean? It means that legal authority in Islam began in private circles. So it is not like the Western and the modern Western legal system in which we have specialists of law, we have judges, and then we have legal profession, lawyers, and a system of adjudication, system of the procedure which is followed in the courts. This was a later development in Islamic history also. Legal authority began in the private circles in which the scholars, the jurists, those who understood the fiqh, and in fact the term fiqh itself in the early jargon, it did not mean only ahkam, it did not mean only law. The fiqh as a term meant general understanding of Islam, general understanding of the texts. And this decline in the terminology, which leads to decline in the minds of the Muslims, the decline in understanding the holistic and comprehensive nature of Islamic knowledge has been pointed and discussed by the great giants like Al-Imam Al-Ghazali, rahimahullah, in his Ihya. He talks about this term fiqh, how it was reduced to the understanding of law only. So in the early jargon, it was always used for general understanding of Islam. So the legal authority or legal understanding began in private circles. The scholars who understood Islam, understood the ahkam in particular, they would sit and teach their students. They would teach the Muslims. Because this is not only a state concern, as in the West, as I told that, as we discussed. This is not only for control and discipline. It is a moral obligation of every Muslim to at least understand the basic ahkam of Islam. It is not only to become a lawyer or to solve only disputes. Remember this, and this is very important. So it is the obligation of every Muslim to understand at least the basic ahkam, which we call fardu ain. Basic ahkam, how to pray, how to give zakah, how to perform hajj, these basic pillars in ahkam. So it began in the private circles, and on many occasions, the scholars who taught in these private circles, they would also have expertise in adjudication. They would have expertise in solving the disputes. So every scholar in a private circle was not necessarily a judge, but this was the case in the majority of the occasions in the early golden period of Islam, that most of the scholars, they were judges also. So after completing their dars and teaching, they would sit for solving the disputes and giving judgments. And this remained the case throughout the major part of the Muslim history. Legal authority remained with the scholars. For this reason, the Khulafa realized that brute power could not yield legitimacy. So the Khulafa, in order to legitimize themselves, they would involve with these private circles and private authorities, the scholars. They would patronize them, they would honor them, they would bring these scholars near to the near circle. Some of these scholars, they became the chief justices, and these posts were created. In the purpose of these khulafa and political authorities was to legitimize their authority. Imagine, this is completely the opposite in the West. The state has the authority, the state has the power to legislate, and the purpose is to control and discipline. Here it is the opposite. The state does not have the authority. And this this vision was destroyed in the modernizing process of the Islamic legal system. Inshallah, we will discuss that maybe in the coming sessions. So here, the khulafa, the state, the political authority does not have any legal legitimacy. The later khulafa realized that brute power could not yield legitimacy. It lay in the preserve of religion, ascetic piety, and moral rectitude. So if they want legitimacy, they must follow the Sharia. They must patronize and respect and honor this legal authority, private legal authority of the scholars who represent the Sahaba and the Prophet sallallahu alaihi wasallam, and they themselves, the Khulafa, must observe piety and moral rectitude if they want to maintain their legal authority. So this is something diametrically opposite in the West, because in the West the state will control and discipline and create legal authority. So we can say it appears to be a consistent pattern that wherever mediation and law are involved in conflict resolution, morality and social ethics are intertwined. So basically, this private authority, the scholars, they represented their society, they represented the people. They were not imposed by the state, but the state had, in order to legitimize itself, had to connect the state structure, the khulafa, the rulers, the ministers, whatever. They had to connect themselves with this authority, because this authority, private authority, the scholars, the great jurists and fuqaha, they did not, this authority was not created from vacuum. They represented the society. The society created them. The society respected them. The society gave them this moral edge. This is very important. So we can say morality and social ethics are intertwined in Islamic legal philosophy. And this is completely opposite to what? To the Western legal system. Those who propound the law, legislate, apply the law, control and discipline, if this law is breached, may not represent the society, may not have the moral edge given to them by the society itself. They are mere representatives of the state. State has imposed them. So presence of coercive and disciplinarian state agencies is the emblem of the modern body politic. If we write this here, defining the Western legal system. Presence of coercive and disciplinarian state agencies imposed by the state is the emblem of the modern body politic, modern Western body politic, emblem of the modern body politic. Is my voice clear? Can everyone hear me clearly? What is the problem? No, I don't think yeah, it's clear. It may be from your side. Yes. So presence of coercive and disciplinarian state agencies, the emblem of the modern body politic. This is completely opposite to the Islamic system. And the modernization of the legal system in Islam by the colonial entities in the Uthmani Khilafah, the Egyptian experience, and other places, even the Malay world, Indonesia, Malaysia, by the British, by French and others. It was basically to destroy this independent authority, independent private authority. Okay. For this reason, when these private circles, and this was a progression in history, it continued, and these circles, the legal philosophy, the law which was taught, later on it was recorded in the forms of texts and books, and these texts, they achieved authority in teaching circles. Commentaries were written on it, glosses were compiled on it. So they also were the manifestation of this private legal authority. Okay. And the first thing which the modernization project did, the distortion project of the Muslim authority, was changing these texts into codes, modern codes. And these codes which were introduced, and we know in the Uthmani Khilafah, the Majalla, which in the late 18th and 19th century, it compiled the Islamic law in the form of articles and codes, is also a form of reductionism which was practiced in order to destroy this private authority, destroy this legal tradition based on this private authority of the great minds, great legal minds. So we can say, as a summary, in Islam, legal norms and social morality were largely inseparable. Legal norms and social morality were largely inseparable. And inshallah, in the coming session, we will talk about modernization of Islamic legal tradition under European influence. The colonization which happened, we'll talk about that, in particularly focusing on our legal tradition. And we will see how they destroyed this authority, and they westernized it. Inshallah, this will be our discussion in the coming sessions. The modern rupture which happened in this particular area. For today, we'll stop here. We ask Allah subhanahu wa ta'ala to grant us understanding, give us tawfiq of engaging with our legacy, understanding it, cherishing it, teaching it, preaching it. This is also a form of jihad. So in these times, when we see what is happening around us, we should not fall into the abyss of emotional thinking. This is one of the problems Ummah has, emotional thinking. Even the greatest movements of modern Muslim history, Hamas, was not created in a day or a night. It is the result of continuous struggle and jihad of 70 years. What we see, their resistance, their resilience, their great istiqamah, is the fruit of this hard work of 70 years. We should not fall into emotional thinking. So we have to engage in jihad. Only jihad is the answer to the Western occupation of the world, and particularly the colonialism which still exists in the Muslim world. However, jihad in its all forms and manifestations. So we should stand for Islam, teach it, preach it, apply it in our lives, leave this legacy for the children, physically stand for the support of and defense of Islam whenever it is needed, and engage in this perpetual jihad. So we ask Allah subhanahu wa ta'ala by His beautiful names and exalted attributes to give us this tawfiq of contributing according to our capability. The problem which happens is when we fall into emotional thinking, yes, Sheikh Yahya did what he could according to his capability. But what are we doing? We are only watching his videos. We are only watching these reels and not doing anything. So our problem is we have become emotional ummah. On these occasions, we are charged a lot, and we also want to do what the great mujahideen of Palestine are doing, but we cannot reach there. So we end up, and we want to do the best or nothing. This is our problem. See, they are contributing, and this is not the only thing Ummah needs. Ummah needs us, Islam needs us on all fronts. So even teaching Quran, if you cannot do anything, teaching Quran to a child is also a form of nusrah to Islam. If you don't have, and this, no work for the sake of Allah is small. Remember this. No work for the sake of Islam is small. Every work has importance. So we should, first and foremost, take this journey of self-discovery. Man arafa rabbahu, man arafa nafsahu faqad arafa rabbahu. Whoever understands his nafs has understood Allah. Our strengths and weaknesses. What can we contribute? And do it in our society. It may be small. You may think it is small, but Allah subhanahu wa ta'ala will not barakah in it. We should not sit back watching only these videos and crying and becoming too overcharged emotionally or sometimes hopeless, and we don't do anything. Stand and take the path of these great mujahideen, Yahya al-Sinwar. You may not have the capability of fighting on the front lines, or you may not have that opportunity of fighting on the front lines, but you have other capabilities. Allah may have given you wealth, spend it in His path. Allah may have given you knowledge, teach it. You may be a scholar, you may be a student of knowledge, stand for haqq. Write about it, speak about it. You may be a journalist, you may be a mother. See, subhanallah, may Allah elevate the ranks of those mothers who gave tarbiyah to such great heroes of Islam. You may be a mother, you may be the head of the family. So train your children on Islam, teach Islam to them, grant them Islamic values. You may be in other capacity, do according to your capability. So this is what the Sahaba did. This is what the great Tabi'een did. This is what the scholars of Islam and the Mujahideen of Islam did. We ask Allah subhanahu wa ta'ala to grant us understanding and to help us achieve the best in dunya and akhirah. May Allah subhanahu wa ta'ala, by His beautiful names and exalted attributes, cure our sick, accept our martyrs, and forgive all our dead. Ameen ya Rabbal Alameen. Wa sallallahu ta'ala ala nabi al-ummi. Wassalamu alaikum wa rahmatullahi wa barakatuh.